Are you comfortable, Judge? I almost called you by your first name now. Judge Mamosebo.
Yes, DCJ, thank you for asking.
All right. Oh my goodness, what's that now? I'm so sorry. Oh Lord. Okay. Okay. You hold a number of academic qualifications. You have a BUris, a BA honors in labor relations, a master's in law, labor and employment relations, an LLB, and a diploma in dispute resolution. Is that right?
Yes, DCJ, maybe I should start by greeting. I didn't greet, I thought you would meet me with that. Yes, good afternoon, DCJ, and good afternoon, commissioners.
That is indeed the African way. Good day, Judge. Is it true that you have all these qualifications?
Yes, I do have those qualifications.
And I noticed that some of them you obtained whilst you were already working.
Not some. From my BUris, I actually had to study part-time because of the circumstances at home. I had to assist financially at home.
And you did that whilst also married, juggling family as a wife and mother.
Yes, I actually got married shortly before I graduated. Yeah, when I graduated, I already changed my surname to Mamosebo, yes.
Yeah. Your legal career is long. And it starts in 1989 when you were a clerk at the maintenance office. That would have been in the magistrate's court, right?
Mpho Magistrates Court, yes.
And you worked your way all the way up through the ranks. You were state prosecutor, you became a magistrate, but you did other things in between.
Yes.
You worked with the Independent Complaints Directorate. You were involved with the Magistrates Commission.
Yes.
And you became a senior magistrate. You were even a BEE consultant at some stage.
Yes.
What is that? What does a BEE consultant do?
Well, I used to advise small and medium enterprises on compliance issues.
And you became a judge in 2016.
Yes.
Where are you stationed?
Northern Cape.
You have applied for a vacancy in the Electoral Court. What makes you believe that you are competent to apply your experience and services there?
It's always good to diversify and to serve in different fields. I believe that as a judge, you acquire skills and knowledge, legal skills, and it's good to apply them in different spheres of the law. So I think I can serve in the Electoral Court because it is not a permanent court, it is seasonal, and I will still retain my services in the High Court while serving in the Electoral Court, just to diversify and to grow in the different fields of the law.
You seem to have done well during your tenure at the High Court. You have a reputation of delivering your judgments promptly and being generally a hard-working judge.
Well, I try my best. I try my best because I believe that justice denied is not supposed to be the way. We must serve diligently in whichever area of the law that we are serving.
As I understand it, you do not have a single reserved judgment as we sit here.
Well, I don't have reserved judgments that will put me in the JSC report. But you know, even before the day before recess starts, you hear a matter.
Yeah.
Yeah, so, well, 2 days before term ended, there's a matter that I heard.
All right. One of the professional bodies, it's NADEL, has asked us to find out from you what skill and insight you bring to the Electoral Court, because you have no prior track record of service on any electoral body or any notable experience and expertise in elections adjudication. How would you respond to this?
Look, I think as a judge, it puts me in a different position. I don't want to use the phrase at an advantage, because already I've learned the adjudicative skills. But I familiarized myself with the Electoral Court legislation, and I've looked at the rules, and I've looked at some of the cases. And I think for me, it's really about serving people, because there I know that it's fast-paced. It's a seasonal court that is busy before and after elections. It's fast-paced, but it involves every member of the community, irrespective of your race, your creed, your gender. Everybody's served. And I think it will be good for me to get into that field and use the acquired skills to better also help develop the jurisprudence in the Electoral Court environment.
All right, I'll hand over to the commissioners to ask you questions, if there are any.
DCJ, I think, is Judge Zondi first.
Judge,
Normally.
I'm so sorry. You know, we did not have a head of court in the previous one. I forgot to even acknowledge you, Justice Zondi. Welcome back, brother. Yes, in a different capacity, of course. Go right ahead.
Wearing a different hat now. Okay, Justice Mamosebo, when did your interest in the Electoral Court start to develop?
Well, I've been following. It's just that because there are no acting stints, I was just following and then thought I shouldn't apply first, but it has been a while now. I think I can safely say, it's over a year now that I've been following developments in the Electoral Court.
So you have acquainted yourself with the law relating to that court and electoral law in general?
Generally, I would say I have acquainted myself.
And thirdly, are you aware that the electoral disputes are by nature urgent and therefore they need to be attended to expeditiously?
Yes, okay. I'm quite aware
so
of it.
That obligation, is it not going to interfere with your primary judicial work in Kimberley, I assume?
I don't think so. I think I'm able to juggle my workload around. As you may have noted from my era as a student, when I was studying towards completion of my master's degree, that's when I also registered for the diploma in dispute resolution, and I was working, and there was no complaint. I'm able to juggle around. Now, the advantage is that in Kimberley, I'm alone. I spend most of my time working and writing or reading judgments.
Thank you, Deputy Chief Justice. I've got no further question for this candidate.
I always forget to switch this back on. Commissioner Bernard, do you have any questions for this candidate?
SDCJ?
I was asking if you have any questions for the candidate.
Sorry, I'm not sure whether you heard me. I said I do have questions. Shall I proceed?
Yes, please.
Thank you. Good day, Judge. I'd like to hear from you the electoral court. If there is a dispute regarding a counting of votes and a serious irregularity, what type of relief can be given by the electoral court?
Well, the counting officer can listen to that dispute, and if it warrants a recount, he can order that. If it doesn't warrant a recount, he can then say his decision is not to order the recount and refuse to deal with the matter, and they can then lodge a complaint or take the matter further, escalate it to the commission. The decision by the counting officer can be escalated to the commission.
And yes, but I'm now at it's been by the counting officer, it's been by the electoral commission, and the complainant is still not happy, makes an appeal to the electoral court, and the electoral court then finds there is a serious irregularity. The question then is, what can that court do regarding what's the type of relief that can be awarded?
Well, the court can order that there should be a recount if needs be, or if it has moved further, if the process has moved further, then the court can order that there should be a by-election if the process has been completed, depending on at which point the dispute is raised. I'm not sure if I'm answering your question, Mr. Commissioner Bernard.
Yes, it's specifically regarding the counting of votes, what can the court find?
Well, like I said, if the recount, if they've ordered the recount and they are happy with it, then the court can confirm that. I'm just not sure if I can take it further than that.
Okay, thank you very much.
Can I confirm it in the Act?
This is not an open, you may. I was just teasing.
Oh, okay. I know I've looked at it earlier. It's all the waiting. I'm doing this because I know that when we write, we have references that we make. Inspection of copies, wait. It's intimidating now, Madam Commissioner. I'm taking my time. Can I come back to your question? Because I see I'm taking your time.
No, this may very well be your last question, Judge. Take your time.
I can take my time.
Take your time.
Okay, no. Yep.
DCJ, I've got a question. I heard you saying it's the last question.
Sorry?
I heard you saying it's the last question. I've
I
got.
was saying it may very
Oh.
well be her last question. I
Please
don't know
note
because
me.
I've not seen any hands.
No,
before.
please not.
Oh, all right.
Yep. An appeal against the decision of the counting officer may be noted within the commission in the prescribed manner and time. And the counting officer must keep a written record. Because I see here, Mr. Bernard, that section 49 deals
just
with...
bring your mic closer to you.
Okay, I'm saying section 49 deals with objections concerning counting of votes and determination of provisional results. That's where I am now.
Yes, but the question is, if the electoral court finds there is a serious irregularity, what can it do?
Or you've moved away from the counting officer.
Yes, we look at section 56 if you want to be quick, save some time.
Yes, it may find that if the irregularity was found at a particular counting station, then they may exclude, let me read B, votes cast in favor of a registered party as a particular voting station must be deducted in whole or in part. That is what the Electoral Court can find.
Thank you. Now, while there's this dispute pending, and it's not, is it possible to then announce or determine and declare the election while the dispute is pending?
I don't think they can announce the outcome then, unless if they've isolated that single station where the irregularity has occurred. But I don't think it will be safe for them to announce the outcome before the matter is determined. That is why it is urgent for the matters to be expedited. And I've noted from the rules that the period is shortened for the Electoral Court to deal with the process, and the chairperson can even give direction if there are issues or processes that must be dealt with where the rules don't cover, where the rules are silent. So that even if the period is 3 days, the chairperson can reduce the number of days to a day or two, can give different directives for parties to finalize the matter as expeditiously as possible.
Thank you. Now, my last question is, it's not possible to declare or announce the election because of this dispute is pending. But the Act does say that the dispute must be, or the election should be determined and declared within 7 days. But now it's not possible because there's a dispute and it might be drawn out beyond that. What then should be done? What is then the process to follow?
Can you repeat that question for me, please?
So if it's not possible to announce or declare the election results because of a pending dispute within the 7 days prescribed in the Act,
Yes.
what can be done? Is there a role that the Electoral Court plays in that regard?
Look, the outcome must be, the decision that must be given by the Electoral Court must be equitable, fair and equitable. So if the legislation says it must be declared within the 7 days, the court must look at what would stop the declaration thereof for the 7 days to be met, the period, the cutoff date of 7 days to be met.
No, it's just that there is provision made in the Act that it could extend beyond that. And the question is, what role does the Electoral Court play in that?
Well, depending on the directions given, the electoral court can hear the matter. Look, the electoral court can determine the matter on paper, or the electoral court can hear oral evidence, or the electoral court can even conduct a trial, depending on what would best be followed to determine that aspect.
Yes, but now that doesn't take place within the 7 days that is prescribed in the Act, within which the matter must be finalized. The result should be announced and declared. So what can the court then be approached for or requested to do?
Can you just give me a moment, please? You see, when you've taken in too much, you must.
We are here for you, Judge Mamosebo.
I think the court can extend the period beyond the 7 days. I just need to confirm with the Act, because I haven't.
No, that's fine. That's fine. The court can, on good cause shown, do that. Thank you very much. Those are my questions.
Thank you, Commissioner Bernard. Commissioner Allen?
Thank you very much, DCJ. Judge, the stopping and going, and the DCJ saying to you, "We are here for you the whole day," and you are accepting that, is that not a sign of an unprepared candidate?
No, I don't think it's a question of an unprepared candidate, Commissioner Malema. I think, for starters, after waiting for such a long time, you must understand that that can affect the performance of a candidate. It's not that I am unprepared, because as you can see, I brought work with me. I have prepared, I have read the prescripts and the legislation, and I've read the judgments, some of the judgments that are relevant. It's just that probably because it's nerve-wracking after the long wait, and I don't want that to be taken as an excuse, because it's not supposed to be used as an excuse.
No, but you are asked a simple question. In a situation where a court finds that there is serious irregularities, what will the court do? You go and open a book. That is something that you should have prepared. If you want to come to this court, you should know that what you basically deal with is serious irregularities. What do you do in that case? You ask for the indulgence of the chairperson to open the act. Is that everybody here? There are judges that are going to come here. Some come. They are very fortunate. There is a new arrangement of new leadership. In the past, people used to wait here until 11 in the evening, and they've never given an excuse that they waited for too long, and therefore we must accept that as a commission, that to indicate that they were prepared, and the long waiting took away their preparedness. What happens when a court finds that there were serious irregularities in this election? That's a question we're asking.
You see, I'll answer that question not based on here, Commissioner Malema. I say, Generally, when there's an irregularity, the court can make a decision to overrule that and correct what has happened and give an order that will be just and equitable under the circumstances.
Like which order?
You see, and here, for voting purposes, if the irregularity emanates from the irregular counting, the court can order that they must do a recount, or there must be by-elections if it is a municipal election. If it is national elections, you can't have by-elections, then those will be excluded. They will be rejected.
So let's take the local elections. What is the difference between a rerun and a by-election?
Well, a rerun is when you do it again, but the by-elections is when those have gone by and you go back again. I'll give an example with, I think, the matter of Mpho, where there were issues raised in the Mpho judgment about people having voted in wrong regions and other people having not, the commission not having updated the voters' roll. I think under those circumstances, the court had ordered that there should be by-elections held because it was wrong for the commission in the first place to have proceeded to that extent without having made available the voters' roll to the different parties and to the independents, and to having allowed them time to campaign, to recruit, to do whatever needed to be done, and to ensure that, to confirm that those people appearing in the voters' roll are indeed as indicated, that they belong or they are ordinarily resident in the regions wherein they said they belonged.
I still don't know what is the answer. Let me ask it differently. By-elections takes place under what circumstances, and rerun takes place under which circumstances?
Rerun, like the term suggests, they will redo everything from the beginning. That's my prima facie view. By-election is when, for example, the elections were held and something happens, and then there's a by-election that is conducted outside the period where the elections were conducted. It will happen at a later stage.
I'm going to argue that you came here unprepared and without knowing basic concepts that deal with daily elections. And I thought I must put it to you so that when I raise it in the deliberations, commissioners don't say I didn't put that to you. What will be your comment?
Well, Commissioner Malema, I can't argue with that. What I know is I had prepared, but probably when I came here, it happened the other way. I had prepared.
Thank you, DCJ.
It's a good thing I was not on the mic.
No, mine is just one question, Judge, is that for sure you are aware that the Electoral Court is almost like it deals with urgent matters where the nation is anxious.
Yes, I'm aware of that.
So if that is the case, do you think that you will be prepared to help deliver quick judgments and solutions as and when the pressure points arise, which is well reasoned?
Yes. Yes, I am prepared and I will be prepared and I will be able to do it. I just want to add one comment, that knowing well that the Electoral Court does not have acting stints. The Electoral Court does not have an opportunity where one can go and test one's knowledge. It is just a vacancy that is open and you apply, and sometimes you are successful, sometimes you're not successful. So you can't say because there's seemingly the view that I seem unprepared, it means I'm not prepared. I am prepared to serve in this court, but if I'm not successful, I will accept. If I'm successful, I promise to do better job and produce better results and seem prepared because I am prepared.
Thank you.
All right. Anyone else? No. Sorry? Oh, I thought you said something. Okay. All right. Now that you've verified that there is no further questions, you are excused, Judge Mamosebo. Thank you very much for making the time to present yourself before the commission.
Thank you, DCJ. Thank you, commissioners.